Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Hello, ladies and gentlemen. My name is Resti Amelia Susanti, and I'm from Universitas Muhammadiyah Magelang. It is delighted for me to present you about my presentation is AI governance and data privacy challenges of AI compliance with Indonesia's personal data protection law. Ladies and gentlemen, as we know, artificial intelligence is a technology designed to imitate human thinking and decision-making process through the use of algorithms, mathematical models, and vast amounts of data. AI has the ability to learn independently, recognize patterns, predict outcome based on previous data, and perform tasks that typically require human intelligence, such as analyze, classification, and decision-making. The presence of AI brings numerous benefits, including increased work efficiency, faster analyze process, minimization of human errors, and opening up innovation opportunity in various sectors, like healthcare, education, security, and business. Additionally, AI excel in collecting, managing, and processing extremely large volumes of data quickly and accurately, thereby generating more precise information or recommendation to support policy making and problem solving. We will move to the next slide. The weakness of AI, besides the many benefits it offers, AI has weakness, one of which is a data protection. The risks of AI use to personal data protection are crucial to consider. Violation can occur when personal data is collected without the consent or permission to the data owners. Furthermore, collected data can be misused if used beyond its original purpose. For example, for commercial interests without the data owner's knowledge, excessive or disproportionate data processing can also pose a risk of data leaks or misuse. Therefore, strict regulation and continuous oversight are necessary to ensure that artificial intelligence usage complies with personal data protection principles, such as transparency, data security, purpose limitation, and data owner access rights. This aims to maintain public trust while preventing the negative impacts of personal data misuse in the era of AI technology. Therefore, laws are important to the regulate of use AI. And so, ladies and gentlemen, this study aims to examine how the personal data protection law in Indonesia regulate ethical principle of personal data processing by AI, including safety, transparency, non-discrimination, and accountability. We will move about the research method. Ladies and gentlemen, now I'm going to explain research method. This research employs a normative legal method combined with a stage approach and comparative approach to the European Union's GDPR. This research also used secondary data which consists of law on Indonesian data protection, book, article, and others related sources to the research. We will move to the protection of personal data protection in Indonesia. In Indonesia, regulation on personal data protection are governed through Law Number 27 of 2022, which serves as the legal foundation to ensure that all personal data processing is conducted safely and responsible. This law establishes important principles such as the obligation to obtain valid consent from data subjects, limitation on the purpose of processing, and protection of data security and confidentiality. In this context of AI, which heavily relies on large-scale data, the personal data protection law in Indonesia requires data controllers to ensure that algorithm and system doesn't process data excessively, opaquely, or without a clear legal basis. Furthermore, this law grants right to the data subject to access, correct, resist, or delete their personal data processed by artificial intelligence system. On the next slide, Law number 27 of 2022 concerning personal data protection is defined as any data regarding an individual who is identified or can be identified either directly or indirectly through electronic or non-electronic system. This definition includes all information that can lead to a person's identity, whether standing alone or combined with other data. The Personal Data Protection Law categorizes personal data into two types. First, general personal data, and second, specific personal data. First is about general personal data, is including basic information such as full name, gender, nationality, religion, and other non-sensitive personal data. About the specific data covers information with a higher risk level, such as health data, biometric data, genetic data, financial records, sexual life, political view, children's data, and other information that, if misused, can cause serious harm to the data subject. And then is about regulation ethic of personal data processing are regulated in Chapter 6 of the Personal Data Protection Law. On personal data protection law, it stimulates that data controllers and data processor have several obligations when processing personal data. They must ensure that data processing is done accurately, completely, relevantly, and in accordance with a legitimate purpose, as informed to the data subjects. Controllers and processors must also maintain the confidentiality and security of personal data through educate technical and organizational measurement to prevent unauthorized access, disruption, and data leakage. Furthermore, controllers are required to provide mechanisms to fulfill the right data subject, such as the right to access, rectify, delete data, and withdraw consent. Other obligations include recording data processing activities, notifying data subject in the event of data protection failures, and ensuring that third parties who process data act according to established instruction and protection standards. Also, the law governs the criminal provision impose a strict sanction on any individual or corporation that abuse personal data. Article 67 until 68, affirming a minimum prison sentence of 4 years and a maximum of 6 years, as well as a minimum fine of 4 million and maximum of 6 million. On the next slide, although Law number 27 of 2022 on personal data protection represents significant step in data protection regulation in Indonesia, has several weaknesses compared to the GDPR, especially regarding the regulation of artificial intelligence use. First, GDPR explicitly regulates automated decision-making and profiling, including the data subject's right to the object to decision solely based on automated system, while the Personal Data Protection Law does not clearly address protection mechanism against base decision or the impact on the individuals. Second, the GDPR mandate a data protection impact assessment for high-risk processing, including a large-scale AI use, whereas the Personal Data Protection Law does not explicitly require impact assessment for AI system. So, it's a living risk of discrimination, algorithmic bias, and data misuse unaddressed preventively. Third, GDPR explicitly enforces the principle of privacy by design and privacy by default, which are not yet normative obligations under the Personal Data Protection Law, meaning AI developers in Indonesia are not legally required to incorporate data protection from the design phase. Fourth, the GDPR provides detailed regulation and standard on algorithmic transparency, including the obligation to explain automated processing logic to the data subjects. In contrast, the Personal Data Protection Law lacks sufficient provision on algorithmic transparency, depriving individuals on the right to understand how AI decisions are made. Fifth, GDPR features a strong independent supervisory authority with broad powers to oversee data processing, including AI system, while the personal data protection law in Indonesia is still in the process of establishing supervisory bodies and doesn't yet guarantee independence or supervisory capacity equivalent to European standards. This weakness rendered the PDP law not fully prepared to face complex AI challenge involving large-scale, high-risk data processing, thus placing privacy protection in Indonesia below GDPR standards, particularly in terms of transparency, algorithmic and accountability, and safeguards against automated decision affecting individuals. So, in conclusion, artificial intelligence has significant capabilities in automatically collecting and processing data, including personal data in big data, thereby offering benefit while also posing serious risk to individual privacy and information security. Law number 27 of 2022 on personal data protection serves as the legal foundation to protect personal data, regulating its definition and classification, obligation of data controllers and processors, and imposing criminal sanction for data misuse. Nevertheless, compared to the GDPR, the personal data protection law still has a weakness in addressing AI technology complexity, particularly in regulating automated decision-making, algorithmic transparency, data protection, impact assessment, and oversight standards. Therefore, the effectiveness of personal data protection in the AI context in Indonesia needs to be strengthened through additional regulation, change technical standards, and more independent and comprehensive supervision. Ladies and gentlemen, that's all for me. Thank you for all your kind attention and participation. It has been an honor for me to share my insight with you today. I look forward to the opportunity of meeting you again in the future. Wassalamualaikum warahmatullahi wabarakatuh.